Hello, I'm Nadia MacLeod from RP Emery Legal Kits, and we help couples secure their financial futures with our online template kits. Retirement savings in the form of superannuation funds have become an important form of family wealth in Australia. But did you know that most separating couples fail to consider super when dividing property after a relationship breakdown? In this video, I'll help bring you up to speed with the basics of super splitting. So, what is super splitting? When applying to split your superannuation, you agree to transfer a portion of your interest to your partner's super account. This portion can be expressed as either a lump sum or a percentage. Super splitting is suitable for couples that have one high income earning member and one low income earning member. It can help boost the receiving partner's super balance to ensure they live a comfortable life once they retire. You can split most super interests with your spouse or partner. However, the law does set out a few exceptions. Any amount transferred must also comply with super preservation laws. This means the funds will remain locked away until a condition of release is met, such as reaching retirement age. There are different options available to couples who intend splitting their super assets. The first option is a superannuation agreement. A super agreement will form part of a broader financial agreement and must comply with the Family Law Act. Among several other requirements, the agreement must identify the super interest, be in writing and signed by both parties, and contain a statement that each party received independent legal advice. The second option is to apply for a court order. This is generally preferred by parties who cannot reach an amicable agreement between themselves. If you'd like to learn more about the division of super in the event of a relationship breakdown, head to our website by clicking the links below.